I'm actually a member of the class, right? I sold a home in this time period. I've done at least 3 transactions personally since then.
What are you doing with your $18?
Yeah, I'll probably go get a, coffee or something like that.
You talk about it privately, we talk about it publicly. This is the Real Estate Insiders Unfiltered podcast.
Welcome again to the Real Estate Insiders Unfiltered podcast. I'm your host, Dwiggy, and I'm by myself today. We couldn't line up calendars. I'm in New York, but this was too urgent not to put out. So you get just me today. We had the famous Ed Zorn, who's been on here multiple times, Vice President, General Counsel for CRMLS, largest MLS in the nation. He came on to address all of the litigation that you are all seeing in the headlines. We talked about the Northwest MLS and Compass lawsuit. We talked about the Zillow and Compass lawsuit. We went through the PLS versus NAR lawsuits, all the different aspects of the litigation, the injunctions filed by Compass, whether he thinks they'll go through or not. He also talked about how to combat listing agents that are pushing private listings. I thought it was a really compelling approach that he takes to that. This is a really juicy one. Put in your ears, kids. Ed, welcome back to the podcast. It has been a minute. I think I should just address the elephant in the room, and that is Keith is not here today. It's just going to be Ed and I. We couldn't make schedules match up. I'm in New York City, and so we thought it was too urgent to get some of this information out. And this one's going to be full of legal update and analysis, although Ed is not your lawyer.
Correct. I am a lawyer. I'm not your lawyer. And James, I'm so much looking forward to the day that nobody in this industry cares what some real estate lawyer hack thinks. I hope that day comes soon.
Me too. I am tired of having these conversations, but I don't know. My gut reaction is somehow our industry doesn't seem to want to learn or listen. So I feel like these will be continuing as much as I wish. I don't want to see you on this podcast talking about legal updates and things. But look, we got a lot to cover today. There's news out from Zillow on their response to the injunction. Compass has filed theirs. We're going to get into all of that. I got a laundry list in a short amount of time. So let's just start at the top.
Sure.
So we got the Burnett Sitzer appeal that has been filed, and I will shut up and let you take it away. Give us a little bit of background on what's happening there. And before we do that, and now that I say it, I've had a lot of people who are aware of this who are concerned with what happens there if the appeal does go through. Are they supposed to follow the settlement? So let's dig in on all of that stuff.
Sure. So first off, don't be concerned. The appeal is extraordinarily weak. It doesn't have a lot of strong basis of it. So I don't expect that to overturn the settlement agreement.
Okay.
But even if it did, right? The fact is, guys, now the rules have been changed. What you guys do day to day as brokers and agents won't change, even if the appeal is granted and we go back to the till and try to do more litigation. Lawyers make a whole bunch more money. Right. But it's
you
not.
Don't see MLS's reversing course on anything?
No,
at this point?
I don't see any scenario where the MLS industry, NAR rules, I don't see any of that changing. Right. Okay. Because we're already now on this new road. To be honest with you, and James, you know this, right? This is a better road. Right.
Yeah,
the consumer-centric model is what we should all be doing anyway. So there's no reason to go back to the old way that caused all the problems just because there's some legal technicality that got tripped up. But again, the chances of the appeal being granted are very low. And so
what are the two main arguments? What are the two main basis of the appeal?
Yeah, one of their arguments is kind of interesting. It's almost a little embarrassing, actually, is there was this argument made that because the judge used and copied a lot of language from a proposed order from the plaintiffs, that somehow that's a reason for appeal. The reason that's kind of weird is when I was talking with a bunch of other litigators and I did litigation on the plaintiff side for 15 years, I've never had a case, James, or a hearing or a motion if I won where I was not the one who wrote the order. How it works in the real world is the winning party usually drafts the order. You send it to the other parties for their comment and edits. You kind of work together as lawyers so that you can present it to the judge, and then he does have a final edit on it. But district judges need to be in courtrooms, hearing cases, doing motions, having trials happen. They can't sit in their back court, their office for 3 hours or 4 hours to draft a 15-page order. That's a waste of their time. So this is ordinary litigation. So a bunch of us kind of had a little chuckle. It's like, wow, that's kind of embarrassing to make that an argument on something that literally happens in every case that exists. So that's going to kind of set the tone, I think, to the appellate court with regard to the quality of the issue with this appeal. The other main one, there's two other main arguments. And one is the monetary relief is not adequate. And there's a focus on the plaintiffs got very little compared to what the claim was, which is very true statement. But so what? You can't get more money out of defendant than they have. So the issue when you're analyzing a settlement on a massive case for fairness is not what the amount of settlement was to the claim. It's what was the amount of the settlement for the people who could pay without going bankrupt.
Yeah, it's funny you mentioned that because I was always sort of smiling going, you went through this in the time in which the real estate industry sucks. Like, it's not an easy time. And all of these companies, as I always say, there's the reason why there's word broke in brokerage. So you can't, the two options basically are get what you can, or the company files bankruptcy and then the plaintiffs don't get anything.
Correct.
So,
exactly. Right. Exactly.
So it's a balancing act.
It is. And that's what the judge's job is. Remember, this is an appeal on a motion to approve a settlement for fairness. Right. So clearly how much the defendants can possibly pay. And the court did a lot of analysis into that. Right. So I think that's going to, doesn't have a lot of leg there.
As a defendant in the Gibson case, which is the copycat case of Burnett, during that process, we gave the plaintiffs our financials. We're like, you can ask for whatever you want. Here's what we got. So it's option A, which is we pay something, or option B, I file bankruptcy and you can go chase sand. So, okay. Third one, I think, was the lawyers were paid too much.
That one, yeah, but that's never going to go anywhere. Just sorry, guys. That's the way
I'm
the world
sorry,
works.
I had to just throw that in there. Like, I had to throw it in there. Yeah. So
the other one was she argues that the injunctive relief is inadequate. The argument here is that injunctive relief, right? That's the order to do something to help someone who was hurt in the case.
Right.
Her argument is the people have already been hurt. So the injunction and the changes in the rules and all of those issues don't do anything, right? Because those people have already been hurt. The sellers are the sellers. The problem is it denies reality, right? And that is unless a seller, a future seller is going to die in the house, right? Unless these plaintiffs that she's saying are not benefited by this order are all going to die in the home that they're currently living in. That's the only way her argument works. But we all know in the real estate industry, I don't know about you, but I'm actually a member of the class, right? I sold a home in this time period. I've done at least 3 transactions personally since then.
What are you doing with your $18?
I'll probably go get a coffee or something like that. So again, it's kind of not super logical, right? We know in the real estate industry, it's an easy argument to overcome.
Yeah.
Right. That 85, 90% of these plaintiffs are going to do another real estate transaction in their lifetime. So therefore, those individual human beings who are members of the class are all going to be benefited by this court order and these practice changes when they do another transaction. So again,
let me ask you this. Let me ask you this, because I think this is in my opinion, and you know where I stand on this. I'm going to piss some people off, but it's my podcast to get to. There's one comment that I do think should have happened. And I think that the plaintiff should have gone further just to have cooperative compensation just outright gone. What's your thoughts on that? Because I hate it, and my stance on it. Like, I don't want anything to do with cooperative compensation at all. Correct. So, and we don't in our company, a lot of real estate companies don't do it anymore. So. Right.
I think that's the better way to go. I've been very public about this as well, right? I'm 100% behind the state of California and what the California Association of Realtors have done. I can tell you I operate a lot in 2 states, right? I help operate an MLS with Art Carter, our CEO, in California. At the same time, I'm a practitioner in the state of Tennessee, where the state of Tennessee has kept cooperative compensation in the forms. It's still done all the time. It's annoying. It's problematic. I have my own. This is a whole other subject for another day. Yeah. I've been caught in a transaction where there was a differential between what I was charging as the buyer's agent and what was offered. And it was a hassle to deal with. None of those problems happen in California, right? California has got the right way to do it. This is an NAR issue at this point. Yeah. NAR has the opportunity in front of them to make sharing of compensation and cooperative compensation unethical under the Code of Ethics. That's what NAR should do. They have the language in front of them to do it. It's 100% on them. And by the way, it'll be way easier for all of you who are struggling with these changes. Talk to your friends in California how much easier it is there than where you are now, where it's still practice.
With you. It doesn't make any sense. There's no reason to do that. I know. I'm with you. All right. We got a lot to cover. Anything else on that before we move on to the next subject?
No, again, don't be that worried about the appeal. Even if the appeal for some reason goes through, it's not going to change what you guys do day-to-day.
Just keep doing what you're doing, basically. Yep. So, all right. Let's talk about the big controversy, Zillow and Compass.
Yeah,
so
lots of fun.
There's been a lawsuit filed and also an injunction request by Compass. Both have, now Zillow has responded to both at this point. We're recording this after the responses. I'll let you give sort of the summary overview and your thoughts on everything.
Sure. To kind of set the stage here, obviously what's happening is, Zillow has their new policy that says if you hide listings from consumers and you still do some kind of public marketing, and so you limit certain buyers that can't see that listing will no longer be welcome on the Zillow platform. Compass apparently doesn't really believe that their off MLS hidden listing stuff works because they complained about that, right? If your system worked, I don't know why you would complain, but they are. And so they filed this lawsuit saying Zillow can't do that. The case is extraordinarily weak from Compass's perspective. Zillow will have an easy win here. The issue really here is with the preliminary injunction. What Compass has asked is that the court stop Zillow from implementing their process right now and wait for the case to be handled. Now, when you're a judge in a case, everything is a balancing act. You got to take the various interests against one another and then put them on a scale and weigh them. So a lot of judges, when there's a lawsuit, you want to keep things the same, right? You don't want things to change. Let the parties have their day in court. Let them fight it out, but don't change things on how they've been for years. And that is Compass's main argument. What Compass has to overcome is a standard in the law that says to get the injunction, you have to have a strong likelihood of success on the underlying case. And that is what Zillow is arguing in opposing the injunction. They're saying, look, Compass has no chance at winning this case. And so even though things might tilt in favor of keeping the status quo and don't change anything, since there's no chance they're ever going to win, we shouldn't, issue the injunction. So I think if the judge is doing his job, the injunction will be denied. Case will move forward and Zillow's policy will move forward. But if the judge kind of errs on the side of caution, I don't want to get overturned on an appeal, and issues the injunction, do not read into that means Compass case is super strong or that they're going to win their case, right? That's just the judge applying that balancing factor tilted towards keep things the way they are now. So I don't get overturned.
And what's the foundation of the case? I've read them, but give us I'm not the lawyer here. So monopoly and a bunch of other things. So what's the foundation of the suit? Yeah.
So what Compass is arguing is one, that because Zillow is a monopoly and they have this market power, that they have conspired or entered into agreements with other competitors in the marketplace to exclude Compass listings from appearing on Zillow. That's kind of the argument that Compass is making. Many problems with the argument. First off, it's very difficult in this situation, this fact pattern. I'm not seeing facts that suggest there's some kind of an agreement or conspiracy between Zillow, EXP, between Zillow and Redfin. Now, Zillow told these companies, here's what we are going to do, right? Okay, so That's not a conspiracy and agreement. And one of the best piece of evidence to that is these listings are still on EXP, right? EXP is not excluding them from their website, right? So Zillow has the right as a company to decide, and this is perfectly allowed under NAR policy, right? Anyone who operates a website gets to decide on an objective basis what listings show up on your website.
So that's actually, there's a paragraph for this, Ed. I was just looking this up. I don't know if you remember which one it was, but NAR has I actually think I have this right here. So they have under their policy, if I've got this correct, you can exclude in the IDX feed because they're using IDX feeds or VAL
Correct.
feeds. But under that policy, in fact, I have it right here. So section 4 of a policy statement 7.58 says participants may select the IDX listings they choose to display based only on objective criteria, including but not limited to factors such as geography or location, uptown, downtown, list price, type of property, condominiums, cooperatives, single, detached, multifamily, or type of listing.
Correct.
Exclusive right to sell or exclusive agency, et cetera. So that's basically stating you can strip down what you show on your website. You're not required to show all the listings per NAR policy. Am I wrong? Did I miss that?
That's correct. So imagine that I have a business that specializes in lakefront luxury properties here in Tennessee. Why do I need to put on my website? In fact, I don't want on my website a condominium in the middle of downtown. You know why I don't want that on that website? I'm not competent to represent that buyer. That's not what I do. That's not what I specialize in. I don't have those skill sets to understand big, tall buildings. Let somebody else do that. So I don't want to use my website. Remember what the IDX website's about. The IDX website is to attract buyers to use my brokerage services to help them buy a home or to help them sell a home. Well, I'm not good at those kind of properties. So I should have the freedom to decide what I want on my website. In this case, Zillow has the freedom to say, look, we are about cooperation, right? We want to work with people in the industry who want to work with us. If you don't want to work with us, that's totally fine. Keep your listing hidden and we won't put it on Zillow. Hey, that's your choice. Zillow has the absolute freedom to do that, as does any IDX
This
platform.
is the part that I'm really struggling with. And look, I have bias here. I'm not denying it. Everybody knows I'm not a fan of private listings. I can put that aside. I don't understand the argument where Zillow is required to show or do business with somebody. That's not how the country doesn't operate that way. As long as it's not discriminatory, you're not required to do business with people. I'm missing this.
Yeah, this to me is the equivalent of walking into the New York Times and saying, look, you've got lots of, you're the dominant paper in New York. You got a lot of readership. I really like the back page of your real estate section. I demand that my listing be on there next Sunday for free. We would all laugh at that concept, right? But that's in essence what this lawsuit is demanding. Right?
What about the monopoly part? This is because they are a big player. They are the largest real estate website in the world by a long shot.
Right. So they're the most trafficked website. And here's the absolute reality of the situation. If Zillow.com went away tomorrow, not a single sale will be impacted. In other words, go forward 1 month, 30 days.
Down
the same identical number of properties will sell with no Zillow in existence.
Well, because the same listings on Zillow on every realtor website, every brokerage website, it's on homes.com realtor, it's on Redfin, so they're not a monopoly in that.
CRMLS right now at this moment sends the listing content to 29,000 websites.
Mm-hmm. Okay.
So Zillow can go away, homes.com could go away, realtor.com could go away overnight. And my prediction would be within, 15, 20 days, you would not have a single difference in the volume or sales or what property a buyer purchases. None of those things would change. So while they are the biggest and they're the most trafficked, that's true. So what? They don't control the buying and selling marketplace.
I find I just find this conversation to be so bizarre. It's like, to me, it's like I have this one group of people saying the world's flat. And then there's this other group of people, which is the majority of the people going, no, the Earth's round. In fact, here's a shot from space explaining that the world is round. I don't know how you make a claim that they're hiding inventory when literally on the front of Compass, it says private exclusives. The only way to see any of it is to inquire with one of their agents. That's literally, unless I've missed the English language, that's called hiding inventory. What am I missing here? Like feel like I'm not.
You're not missing anything. In fact, as I look at my other screen at my notes, I have under this issue, under very weak case by Compass, illogical. That's like a heading.
It doesn't make any sense to me.
Right? Why does Compass need Zillow? You're the best real estate company in the world, according to you. Right? You've got this masterful marketing system where you don't need to cooperate with anyone else. Cool. Go sell the property. What do you need somebody else for?
I don't get it. It's kind of, the whole thing is just so strange to me. So, all right. So you're in the camp of this goes nowhere, maybe an injunction, but the case doesn't have.
I think the injunction is unlikely. It could happen, but I don't think the case is going anywhere.
Okay. Anything else you want to add? We'll go to the next one.
No, we can go to the next one. There's more to go.
Yeah. So again, with Compass, Northwest MLS lawsuit. And you and I have talked about this just briefly. You actually have some, there is a part of this I know you have a concern about. So let's go into the background on that, and then we'll dive into some of your thoughts there.
Sure.
So
I think for your listeners to realize here, when we start talking about Northwest MLS, is they're very unique. So no matter what happens in this case, it will have zero ramifications on what happens across the country. And the reason I say that is Northwest MLS is unique in a couple of ways. Number one, for I think 15 years, they have had basically a version of CCP that is actually more stringent, with no opportunity for an office exclusive. Office exclusives have not been allowed in that Northwest MLS marketplace for 15 years, plus years. Okay.
And Ed, real quick, just because I want to add context. So for viewers and listeners, we've done 2 podcasts with the 2 largest real estate companies up there. So Windermere and then John L. Scott. So Lennox, both Obi and Lennox were on to talk about this because they're members of that MLS. So 2 of the largest companies talking about why they don't do office exclusives. Just want to add context. We'll put them in the show notes for you to see them.
And it's great too, because realize those companies are so much more dominant in that marketplace.
Massive.
Than Compass is in almost any other marketplace of the country, that they could have an advantage if they embrace these arguments. And
Windermere's 30%.
Yeah.
Windermere's 30% market share, and they are massively against office exclusives.
Right. So just keep that in mind, right? That's very different than other MLSs. The other big difference is that, let's go through the facts, kind of what happened, right?
Yeah, go.
So, Compass wanted to hide listings, right? That their program of hiding listings. It broke the rules because they decided to break the rules. Northwest MLS cut off their IDX feed. Now, they didn't kick Compass out of the MLS. Right. So every single Compass agent still had full access to the database, could still show properties to their buyers, could still list properties in the MLS. Right. They could do all of their brokerage work. Right. It's just the other brokers in Northwest MLS's listings were not going to appear on the Compass website, which makes, by the way, perfect sense. Right. If Compass is going to say, I don't want my listings to appear on your guys' websites by keeping it out of the MLS, then why should Compass get those agents' web listings on their website? It's kind of, I think there's an argument that could be made, and I think this is kind of the approach Northwest MLS took, that if you're going to hide listings behind an exclusive agreement and not put it into the MLS and therefore not display them as IDX, isn't that in essence an IDX opt-out? Aren't you saying, look, I don't want to participate in this IDX system? That's a logical way. And obviously that was a problematic. And so that kind of, caused a riff. And then Compass started using open listings, right? And then not putting those in. And then Northwest MLS then had a rule change because, like most MLSs across the country, most MLSs do not accept open listings into the service, right? Even in CRMLS, right? Our rule, in fact, this is national policy, that the clear cooperation policy, that's submitting a listing upon public marketing, does not apply for an open listing or a non-exclusive listing, right?
All right, let's stop for a second just because I want to make sure everybody understands this, because whenever I talk about open listings, I get blank stares in the
Yes.
room. All right, let's go back real quick. Explain what an open listing agreement is versus a exclusive, right? So just give us the differences so we can get a little foundation before we go deep into this policy. So I think it's important.
Yeah, great point. So we are all used in the United States and Canada to exclusive listings, right? And what an exclusive listing is, it basically says that no matter what happens, I get paid as a listing agent, even if you completely fail and you don't find the buyer, right? In a non-exclusive or an open listing, what that contract says is if I participate, if I procure the buyer for the seller, then the seller will pay me a fee. But if I do not procure the buyer, if I'm not the one that brings the buyer to the deal or didn't participate in the buyer getting there, then the seller doesn't owe me any money for, which makes sense. Let's be honest. You failed. You were hired to bring the buyer. You did not bring the buyer. Why should you get paid? And by the way, this is how it works in every other place across the world other than North America. Now, why do we have exclusive listings? Because of the multiple listing service. Because of it encourages cooperation. So that's why we have exclusive listings, and that's the norm. But with a non-exclusive, what the seller has is the choice. Realize an exclusive listing eliminates sellers' choices. It limits the seller to only interact with the one broker firm they signed the listing with, and they lose the opportunity to deal with buyers that are unrepresented. They lose the opportunity, this is a seller, lose the opportunity to work with another broker who may have a buyer for their home. So exclusive listings are restrictive and limit sellers' choices. Now,
so what you're basically saying is the best argument for seller choice is an open listing agreement.
Absolutely. In fact, again, that's why every other place in the world that does not have a multiple listing service, you're going to have a very hard-pressed time convincing a seller to sign an exclusive. We've talked at CRMLS to other countries who've come to us asking, how do you set up and how do you establish an MLS? And we start right here. We start with exclusive listings. They usually get very dejected. And their immediate answer is, what seller in their right mind would ever sign an exclusive listing? We would never be able to get our sellers to do such a stupid thing.
It's amazing
That's
how
their
much
response.
we have such like a naive perspective of how real estate works around the rest of the world in this country.
Yeah. So what the open listing gives a seller is the opportunity. It opens it up to the marketplace, right?
Yeah.
So that if I have an open listing agreement with you, James, and I advertise it and I put a sign up, right? And another agent sees that that's for sale, understands that it's subject to an open listing, they don't have to go through me. They can go directly to the seller and represent their buyer to the seller and try to do a deal. That's what their license lets them do.
I want to just frame this real quick. So the reason why people don't like open listing agreements is because of that, because they're worried about not getting paid.
Right.
The reason why the MLS only works with exclusive listing agreements is because you're telling all the other agents that this property is for sale. So it guarantees that you get paid. So the foundation of the MLS is actually protecting the agent and brokerage.
Correct.
To some degree. Right.
I want to be super clear. Exclusive listing agreements are fantastic. They are great for the seller. They should be done all the time. That is the preferred way to do things, because every exclusive listing should be subject to the rules of cooperation in the MLS so that everybody has access to that same property in the same way, following the same set of rules. That's the beauty of what we built. Now, there are situations where I'm going to argue it doesn't make sense for a property to be in the MLS. And in those situations, the solution is the seller should then sign an open listing or a non-exclusive listing so that the seller still has their choices and their opportunity to engage with other brokers who may have buyers for their property.
So basically what you're saying is that if somebody cares about seller choice as much as they're screaming from the rooftops, and it does matter to the seller, there's an option that's already been available for the longest time that you could offer a seller, and then clear cooperation doesn't apply. By the way, I verified this because I want to do my research. Neither does the Zillow ban.
Correct.
It does not apply to open listing
specifically on
agreements.
exclusive listings. Exactly. The Zillow ban doesn't apply either.
So Zillow's ban, the rules of the MLS don't apply. If the seller wants their freedom to do whatever they want, offer the seller an open listing agreement and problem solved.
Correct. Absolutely. Right. And it's a very effective solution for those super unique properties that don't belong in the MLS, which I fully acknowledge those are out there.
There's a small percentage of them.
Absolutely.
I've said the same thing. Everyone's like, why do you force it? I'm like, I don't. There are situations. It's less than 1% of the time. Otherwise, the best scenario is this. Right. All right. So frame this up. We've got understanding of what that is. Now, the Northwest MLS, they don't allow. Give us a background on the open listing agreement with them. So there's been some stuff.
So for many years, they did not take open listings into the database, right? And again, open listings are very rare,
basically.
Right. But what ended up happening is they actually modified their rules when Compass started doing this practice, and made it where open listings were allowed to be submitted to Northwest MLS. And then they made open listings a requirement of their mandatory submission rule. So they kind of changed that rule. And that is really one of the things that Compass is arguing. Now, in looking at the lawsuit, Compass's arguments are very weak again. Their Northwest MLS has brought a motion to dismiss. It is excellent. It is well crafted. It really highlights the antitrust issues that Compass is going to have a very difficult time overcoming. It's really what we call the free rider problem, right? So there's a concept in antitrust law that I don't have to, I'm allowed as a company to make rules and policies and systems so that people don't free ride off of the other people in our group, right? And a free rider problem would be this. I'm not going to put my listing in, and I'm not going to share my listing with anybody else in the MLS. But James, I'm going to use your office's closed listings to do my CMA. I'm going to look at the photos that you put in the MLS to compare the kitchen to the kitchen of the home I'm trying to give an opinion on. I'm going to use your listings and all the other brokers' listings in the MLS to look at and develop a good list price and to provide quality opinions to win the listing with the seller. And then I'm going to take that listing and I'm not going to give it and share any information with any of you. The nice term in antitrust law is free rider. We could say leech, freeloader, right? There's other phrases we could use that are maybe more descriptive.
Well, and I think that's a really good comment. And this is the part that I think everybody, including the ones that are for, private listings, like you need to grow up for a second and look at what you're actually asking for. Like it's not fundamentally right. It's just you're wanting it one way, but then you want it the other way where everybody else is playing by a different set of rules. And that's just not that's where I think this is a real issue for me is you can't have it both ways, Right. And it doesn't mean that rules can't be changed, by the way, but it's just very self-serving in the way that this is going down.
Correct. And I think that's one of the concepts there. That's really important to highlight. If we could fix this with a technology solution instead of a rule, I would be the first to do that. If the technology existed that said, if you're not going to place this listing that you're taking, that you're trying to get in a listing presentation into the MLS on day one, then I would bar you from seeing any photograph, any listing of any other broker in the system. And now go make your CMA. Now go make your pitch to the seller with only the sales from your own office, right? If the technology was around to kind of level the playing field and make that fair, we could maybe do that. But that's not how it works. I can't do that, right? And so now I have to do it through some kind of rule, which is, look, you used all of the other brokers' information, all of their data, all of their photos, all of their work to secure and get this listing. The cost you are required to pay to do that is to be fair and put that listing into the multiple listing service. If you don't want to do that, that's fine. Then take an open listing, put a sign in front, And if I represent a buyer that I think that home might be appropriate for, and I reach out to you and you ghost me and you don't respond to me, you don't cooperate with me because you're trying to use the sign as a billboard to drive more traffic to your own firm, that's fine. You can do that. You know what I'm going to do? Going straight to the seller's door saying, hey, the guy with the sign out there, I called him 3 times. He wouldn't call me back, just so you know. And now I'm here with a great offer from a great buyer. That's the way the process, that's open competition. And the way the rules are written, that's exactly what we have, right? Except my concern in the Northwest MLS scenario is the open listing thing. I think that's the space where there's a really opportunity for maybe a resolution or a settlement, right? To maybe get rid of this lawsuit would be, hey, you know, if Northwest MLS kind of took a step back off of the open listing ban and Compass could live with that, then I think there's a resolution. But I'll be honest with you. I think there's a 60-70% chance that Northwest MLS wins anyway, even with their open listing ban. That I think the arguments that they make are so strong, and the freeloader problem still exists with open listings, by the way.
Yeah.
Right. So that argument can still carry the day, where even open listings can be forced into the MLS. Right. I think.
But your comment seems to be very, in fairness to Compass, your comments about open listing agreements are allowed everywhere else, essentially, other than maybe there are a few others. But if we want to have the concept of an open listing where the seller gets to have the choice, then that should be an option. And I think you're kind of alluding to that to some degree, that's maybe the path for it. But I mean, your freeloader comments certainly make sense to me. Look, it's not like, and everyone's going to be arguing me in the comments now, it's like, all these rules and all these fines and all this stuff. I'm like, yeah, by the way, these rules and stuff came out because people were doing shit that that skirted or negated things or were screwing other people. And that's like, welcome to America. That's why we have so many damn laws. All right.
Can I address that real quick? Because this is an important point.
Yeah.
For all of the people who get a fine and bitch and whine and moan that they had to follow a rule that they agreed to follow, which I don't quite understand why you're bitching and moaning when you agreed to follow the rule. It's CRMLS. We process 30,000 reports of rule violations a year. 30,000.
And the rule violations are reported by other members. Is that correct?
By other agents. Other agents report the rule violations. Okay. We only issue fines at around a rate of about 11% of those. So almost 90% of the reports come in. We work with the listing agent in an effort to fix the problem without ever sending out a fine. So what that means for me as a multiple listing service, though, James, realize it's a 9-to-1 ratio. For every one person who broke the rule and is bitching and whining that they got a fine, I have 9 agents who contacted the MLS and demanded that we enforce the rules that everybody agreed to, that they demand that it be fair and enforced. So for those out there who think MLSs are being harsh because they're being mean to members, or why are you not taking care of the members by fining them? I am taking care of my members. I'm concerned with the 9 members who followed the rule and are doing things the right way. And that's who I'm going to back, not the whiner or complainer who said, I will follow this rule. I promise to follow this rule, and then violates it anyway. I don't have a lot of love for that.
And I get it. And it's not, but also the rules are set by the board, which is members of the MLS. So,
well, and they're also set. Let's be honest, guys. If everybody in the real estate industry was an angel, I wouldn't need the rules.
Yeah. No,
the problem is we have
kind of a funny argument
out there who have a superior base of knowledge, have access to more information, who are highly skilled as compared to a consumer who does this transaction maybe 2 or 3 times in their life. And there's an easy way to make great money by hurting the consumer, right? Because of your superior knowledge. That's what the rules are for.
Well, it's like, people complain about, all these rules and laws. And it's like, well, they don't complain about the fact the rules exist to stop drunk drivers. because they weren't obeying the laws to begin with anyway.
Right.
So,
Yeah.
all right. We got a few more to go through. So we talked about that. Let me ask you this, and then I want to get to a couple more. What do you see as the risks in doing private listings? Let's summarize that in like 5 minutes. Because in fairness, everybody, I've had some conversations with lawyers as well, other than Ed, on the actual antitrust side, because I got to go through litigation in the Gibson case. My lawyers were like, "This is really bad." They were not shy about, this is a ticking time bomb, but I'm going to let you give your explanation on it. So, because you're the lawyer, I'm not.
Right. Let me set the stage for this, right? Because we have not seen a lot of litigation. And so people will point to the fact that we don't see sellers suing their own agents. So when I was with the Inlet Gateway Association of Realtors on Pro Standards from 2002 to 2007, 5 years, we had 0 arbitrations between a seller suing their listing agent. Guess what happened in 2007 to 2008? In 1 year as the ombudsman, I handled 28 claims from a seller wanting to sue in arbitration their listing agent to get money from the listing agent. Mm-hmm. So 5 years of 0, market shift, 28 in 1 year. Mm-hmm. That's what's in front of us. So here's the risk, right? When you hide listings and a seller finds out that or at least thinks they could have gotten more money having that listing exposed to the open market, or they run into somebody who says, wow, I see you sold your home for X dollars. I know somebody who would have paid more than that, right? You get a couple of those kinds of things in the mind of a seller. Now the seller's going to go in and have some really good arguments to say, look, I signed an exclusive agreement and my opportunity to take an offer or to consider other people were taken away from me with this exclusive agreement. And you, listing company, you use that ability, right, of exclusivity not to sell my home. You use my home as a billboard to drive more traffic to your agent, right? And so as a result, I was harmed, right? So that's a significant liability out there with sellers. I actually think there's a potential or a risk for a class action suit from the buyer and buyer agent community as well. Again, attacking the exclusive listing agreement being kind of restricted. And I mean, let's be honest, the state of Tennessee has given me a license that says, Ed, you're allowed to have a buyer hire you and go find a home for that buyer to live in. And that license gives me the right to talk to any seller, any property owner in the state of Tennessee to see if I can put a deal together for the buyer that's hired me. Right? But if there's an exclusive listing agreement and under Article 16 of the Code of Ethics, there's an exclusive listing agreement, I'm not allowed to go to that seller, right? Under those set of rules. And that's totally fine as long as I have access and my buyer has access to that listing in the multiple listing service subject to the rules of cooperation. But if it's not in the MLS and there are no rules of cooperation, why am I not allowed to go straight to the seller? Buyer hired me to go find him a property. I see a sign on this property. Why can't I go do a deal? Right? And so there's an argument there
on the buy side
too.
The buy
side. Yeah. And here's the risk, guys. That's attacking exclusive listing agreements. Do we really want to be doing that? I don't want anyone to do that.
Well,
I think the listing agreements are great.
Everybody talks about, we're giving the seller options. The seller can there's multiple options on the path they go. And they're choosing and acknowledging in an informed consent that they are okay with not having it on the MLS and going through this particular path. I argued that there's a study from Deloitte that shows 90% of American consumers don't read a single damn document, by the way. All that aside, is if they sign an informed consent, does that remove the risk for the listing brokerage and agent?
No, not even close. I can tell you as a plaintiff attorney, I'm going to sit that seller down in a deposition. I'm going to ask them these questions, right? I'm going to attack the informed part of your consent, right? Did your listing agent tell you that on average it takes 3 weeks longer to sell a home if it's not in the MLS?
No.
Okay. So did your, right, like that right there, are you really informed? Right?
No.
Did your seller, I mean, did your listing agent tell you that if we only expose the property to 3% of the agents in the marketplace, we're really not getting a full feel of what this price will attract? Were you
Let's
told
just,
that? I'm going to argue that when I sit that seller down in a deposition, I will go through questions of what I consider as a plaintiff lawyer to be informed consent. And I guarantee you they're going to be different than what's on that piece of paper.
right. And that's essentially where you break that down. And I guess your point is you put that in front of a jury or a trial and it's all over with because they're going to look at the big bad corporation.
Yes.
So, I guess my question is this, are we looking at another ticking time bomb if private listings grew in popularity? Is this a bigger class eventually? I mean, what the lawyers told me is there's no class action because the class isn't big enough yet. It'd have to be big enough for them to make it worth their money. But they said if it becomes big, yeah, potentially. Are they off? Like, what's your take?
I agree with that fully. Right. Right now, we're talking 1%, right, of the listings. That's not big enough to be that concerned about, right? If this became 20% or 30% of the marketplace, absolutely, these suits will happen.
Okay. All right, two more, and then we'll wrap. Because I think people miss this, but PLS sued NAR again.
Yes.
It was on hold. Now it's back again. It's like the never-ending drama show. So I guess real quick background. Like, let's do this in a few minutes, and just any concerns there.
Yeah, so there was a previous case, NAR won at a
private listing network.
Right, it's the private listing network versus NAR.
Yeah.
CRMLS was actually part of this other case as well. They brought a motion to dismiss. The trial judge said, "We're granting the motion to dismiss. The case is so bad that we don't even think you can amend the complaint to state a cause of action." Right? Then that was appealed. It was overturned in the Ninth Circuit, but there's something really important to remember. When you appeal a motion to dismiss, the rule is this: the judge has to assume every single thing written by the plaintiff is factually 100% correct, even if it's an outright lie. Okay? And it's those are the facts that go up on appeal. So I call them the fantasy facts, right? So the fantasy facts are on appeal. The Ninth Circuit kind of grabbed onto a couple of the fantasy facts in overturning and sending it back to the lower court for a trial, right? So I don't put a lot of credence or value in the Ninth Circuit opinion because it's based entirely on fantasy facts. When you have different facts, those opinions go away. So that's one thing. And so a bunch of us resolved that case. NAR resolved the case with the PLS. But when NAR resolved that case, they did so without prejudice, meaning, look, we're going to give PLS the right to refile the case. Because remember, at that time that was resolved, there was a lot of debate of whether CCP would be, changed, modified. NAR did come across and do some things with regard to that. PLS was not satisfied with that, so they decided they would like to bring their case again. Very weak case. Again, the reason that PLS is going to lose that case is the open listing agreement exception, right? And that is they keep arguing that, the sellers are restrained, from doing what they want, but all you got to do is take an open listing, right? They also argue that the reason NAR and the MLSs kind of agreed to this is because we were afraid of these competing MLSs, about that's a laughable argument because PLS has been around for a long time. Nobody left CRMLS because there was another listing platform to use. Nobody left CRMLS because Zillow has a good listing platform. No agents left CRMLS because Realtor.com has a good listing platform. And Art Carter has coined this phrase. It's very true, right? He says, look, consumers do search, agents do research. And what he means by that is you use the MLS as an agent to do really deep dives. You got to get into really understanding the information, really understand comparables, market conditions, communities. There's a lot of things we do as an MLS, as a broker cooperative, that these listing platforms never touch, never expose. So they're not a competitor to us in any way, right? And so...
I mean, they get their data from you.
Well, the Zillows, right. I'll be honest with you, James, I've made this argument to the Department of Justice, right? That we're not a listing platform as a multiple listings. We're a broker cooperative, right? We have rules of how we engage with one another that have nothing to do with the data or a listing, right? Those are just listing. They're not different than Craigslist, right? The PLS and Craigslist, the PLS and Facebook are the same thing to me. Yeah. I'm not threatened if someone puts a listing on Facebook. Right. So I think it's a very weak case. I don't think it will really go anywhere. It'll have to run through its process, but it's
the
very...
lawyers make more money.
Yeah.
Basically. Yeah. Okay. All right. I want to end on this, and you can tie the two together. You've been very passionate about, and I want you to go on your soapbox because I think it's actually really interesting to hear you do it. You like when companies are doing private listings personally as an agent, not as the MLS General Counsel, because you basically go, I will squash you in every listing presentation. This is what kind of your words have been. So
I probably would say that I like it. I think it's not good for the community, but it would not concern me. In fact, if I was going to go on a listing presentation, I would be very happy if a We Hide Listings company was against me.
It's okay. Right? Thank you for clarifying my comments. Yeah. But you're like, I will go up against that all day, every day. So give us the pitch on how you would compete against somebody who's trying to push a private listing to a seller versus how you would approach that on a presentation.
Yeah, a couple things. First, I would warn the seller that there may be some agents out here who are going to try to pitch you on this hide your listing, right? And I would use data, right? And so one data point you can use is the filings of Compass, right? Compass has filed lawsuits, and here's a company that has a hiding listing system, and they acknowledge in that lawsuit that it fails 94% of the time, right? That's in the lawsuit.
So I'm going to play Compass for a second. That they 94% of the time, the listings they put in the 3-phase marketing plan end up on the MLS. Correct. You're turning that around, saying that it doesn't work 94% of the time.
That's what they said. I'm just telling you what they said.
Yeah, right? I got you. Yeah.
So they said, right? So if you're up against one of these hidden listing, right, realize, look, the data suggests this has a 94% failure rate. And it adds, and we know this from CRMLS's data, we've published this data, right? That if you start a listing off MLS, it takes 3 weeks longer to sell. So you should be informing yourself. And again, I talked about this with informed consent, right? This is what, by the way, the hidden listing agents better be telling their sellers also, that it's a 94% failure rate and it takes 3 weeks longer to sell, right? Mm-hmm. I think that's almost enough to kind of, get over the hump. So I think the other important thing I would stress is if somebody comes in and demonstrates a low days on market, an average, right? We do this in our listing presentations, right? You probably have calculated your average days on market over your last 10 listings, 20 listings last year, right? You have some kind of measurement and you use it to demonstrate how a good agent you are, right, James? Right? So realize though, DOM, days on market, CRMLS has changed our label for that. We calculated exactly like we always have, but we've changed from days on market to days active in MLS. And I think that's a much more accurate reflection of what that number is. So even if your MLS has a DOM, D-O-M, I would, if they calculate, and the way they calculate that is basically just counting the days active in the MLS, I would go into my listing presentation and I would say, look, whenever you hear someone use, days active in MLS, that is simply a reference of how great the MLS is. Tells you almost nothing about the agent, by the way. right? Because the way that days active in the MLS is the marketing time where it's exposed to all of the other cooperating brokers. What does that got to do with you as an agent? Right. What I would calculate is I would calculate total days listed. So I would go to my last 10, 20. Now, you got to be a good listing agent, guys, for this to work, right? And what I would do is I would go from the list contract date, right? When the listing started to the day it closed. And my argument would be this. This tells you how good of an agent I am. It tells you how fast I got your home ready for market, right? How good was I getting my photographer in and my staging done, right? And then once we get into a contract, it tells you how good was I at helping you pick the right buyer. So we didn't get a buyer who was going to fall out. How good was I at analyzing the quality of the loan? How good was I at negotiating a repair issue or an appraisal issue, right? So total days listed is such a more accurate reflection of the quality of me as an agent. So I would have that calculation.
Sure. So you're basically saying that they take a lot longer and you can do it in a shorter amount of time for a higher price, which is all the seller wants 99% of the time anyway.
Right. And anytime I'm going up against the iHide listings agent, he's already starting off with 3 weeks longer than me.
Yeah.
Right.
Okay.
And so that I think would give me some kind of advantage.
What about testing the price? And we'll end here just for time's sake. I mean, I hear this all the time. I don't even get it because I'm sitting here going like, this is supply and demand economics. You can't test a price unless the actual potential buyers can see it. Like, what am I missing on this argument?
So that's a good logical economic response to that. There's another one. Now, I am the first to admit 1/2% of homes, very unique. You know, maybe they're in I owned one of these houses, right? I had a 7-acre property with a really unique house on it in the middle of suburbia, right? Where everything was tract homes, right? You had to go 7 miles away to find a comp. I get that. So setting that aside, for 99% of the homes, my response would be, and I would tell people this in my listing presentation, beware of somebody who needs to test the market. Isn't that an admission of incompetence? Like, why are you hiring someone who doesn't know how to price your house? I am a good agent. I have access to great information through the multiple listing service. Here is my CMA and why I think the price should be in this range. I don't need to have someone test the market. I am a skilled agent. Yeah. Why would you hire somebody who doesn't understand or know what your house is worth?
Yeah. I can't answer this.
It blows my mind when people say that. I'm like, wow, you're admitting that you don't know what you're doing.
Yeah. I mean, isn't that why they hire us, is to be able to figure that stuff out?
Right. That would be my pitch. So I would have a slide in my deck that says beware, right, of these tactics.
Yeah.
Right? That's why I say it. I'd be very happy to go up against the iHide listings type of program.
And in the scenario where, we'll wrap here, in the scenario where we have a seller who needs to have privacy, they can restrict the address inside the MLS today, correct?
Yes.
So that it's not visible to the consumer. Yeah. And you have internet no, meaning it's in the MLS for other agents to be able to know their properties for sale, but it's not on Zillow or brokerage sites or agent sites for the public to see. Did I get that right?
You did. Those two. And the internet no, this is a little snapshot into the legitimacy of the people who are making these arguments, right? Internet no also means it's not on Zillow or any of these outside websites. It's also not on Facebook. It's not on any of your listing firms' websites. So when people talk about privacy and they leave out the argument about internet no, that what they want is they want it on their website. They just don't want it on your website. Right. And that's the rub, and that's the problem. But yes, okay. we can do internet no and accommodate the pricing. And then if that still doesn't work, do an open listing. If
so there are plenty of options.
Property, it doesn't belong on the MLS because of price, or it's really a hard property that only would go to an investor or something. Keep it off the MLS and take an open listing.
Yeah. Okay. And Thanks again for breaking this down logically for everybody in the updates on all the legal stuff. We'll have you back on at some point when all of this mess
Hopefully not. Hopefully people just don't want to hear from any of this junk anymore. We can just move on.
I really don't want to be
and help consumers.
Every time I go somewhere, people are like, thanks for covering all the lawsuit stuff. I'm like, I really want to talk about something else.
Exactly.
So, all right, my friend. All right. Appreciate you.
Great seeing you.
Thanks.
Bye.
Okay.
Don't make a rookie mistake. Subscribe now so you can be the coolest person at the water cooler. Who actually wrote this?